Okay, welcome back everyone. So the thing that we need to be looking at is bail today, but I said that we discuss the assessment one, just so that you know what I was looking for, expecting from you guys. And then you'd be able to self-assess what your, whether you've hit the nail on the head or completely missed the boat. All right, so the question was, the traditional response to an offense is that the state brings criminal charges against the perpetrator and a court imposes punishment upon conviction. In recent years, there's been a move away from trial as the only manner of dealing with criminal conduct through introduction of alternative means, which are usually based on consensus. In addition to restorative justice and diversion from prosecution, the National Prosecuting Authority uses informal mediation as a means to finally dispose of criminal cases. Almost a quarter of all cases finalized in 2015 and 2016 were resolved by informal mediation. In an essay, discuss restorative justice and mediation and their place and role, if any, in the practice of criminal justice. All right, so how did you approach this? Well, I've seen how you've approached it, and ideally, this is what you ought to have done or dealt with. So you had to have given some sort of historical perspective. When we talk about historical perspective, what I mean is, what is the traditional system of criminal justice operative and operational to the larger extent in South Africa? And here you'd be talking about crime control versus due process models. You'd be talking about traditional courts and the adversarial role and its adversarial method that is followed here in South Africa. But at the same time, you'd be leaning towards, and this is where then you'd have to talk as an alternative or as a possibility, because this is what your assignment or essay is meant to be about restorative justice, itself, right? So, about restorative justice. Now, you can't take for granted that your reader knows what restorative justice is or what mediation is. So aside from giving a definition, you'd also have to talk about its role and place. Now, some of you are able to consider, and yes, obviously international perspectives, because the point is that it's not necessarily something brand new and it's not necessarily something alien to criminal justice or justice as the system of justice. Restorative justice, mediation, and these methods exist in from a cultural perspective, and here you could be talking about things like Ubuntu, but also when we talk about other legal philosophical principles or ideologies, you could be leaning on and referring to what the international perspective on the same philosophy is. And although they might call it something different, the system actually does exist. And that's the thing. Does restorative justice mediation feature in South African criminal justice? And yes, it does. It does, but to what extent? And what is the efficacy? Is it useful? Does it wipe out the traditional courts, as in the courts of justice as we know them today, or as we've known them for centuries? Or do they work in parallel or as an alternative system? And this is it. Can we say that one is better than the other, that one trumps the other, that one will get rid of or ought to get rid of the other? And the focus point or the focal point that you'd be coming down to is that no, they're not rival systems. Again, as we saw with crime control and due process, restorative justice isn't a rival system. It's a system that works and can work well, depending, of course, on the nature of the offense. And not very many of you picked up that it had to do with the nature of the offense, so the seriousness of the offense. And like I said, does it work? Well, yes, and when. So we talk about things like the TRC, youth offenders, diversion, etc. Okay, and then also you'd be talking about, and in doing so, you'd be talking about pros and cons. Right. So you understand, and obviously your resources. Some were given to you as part of your required readings, but those weren't the only sources available to you. You've got all access to the internet and all of those resources, and some of you may manage to pick up case law and discuss the case law as well. No, it may not be reported cases of matters that had gone on mediation, but certainly matters, criminal matters that suggested that perhaps in these circumstances, mediation would have been a better alternative. Okay, so any questions thus far regarding the assessment? Any questions? No, okay. So we can move on into today's topic, which is coming at quite an opportune time, the issue of bail. And there's two particularly high profile matters which are currently being reported in the news regarding bail. The first one is that the bail application of Ace Magashule, and the second one is um, the Bushiri matter, where they've violated the conditions of their bail. So to your mind, what is bail? And what does the granting or not granting of bail mean? Anyone? So yes, go ahead, Michael.
Thanks. Good morning, Ms. B. Thank you. For me, bail is about serving the interests of an accused person, and not necessarily fully the public interest, because it may be that to grant a person bail, well, an accused person bail, could, in terms of the accused interest, be to enable the accused to continue work if he's a working person, so as to provide for his family or her family. But in terms of the interests of society, it could be that it infringes their interests as a collective, because bail may endanger those persons who the criminal or whatever conduct that he is accused of being committed will infringe their rights, and he may maybe interact with witnesses or whomever will be relative to the case.
Okay. Tinashe, go ahead.
Good morning, Miss B.
Morning.
I also think bail is probably directly linked to the presumption of innocence. So I think the court upholds the presumption of innocence by giving you bail until the trial is over and until all the evidence is collected and a judgment is passed.
Okay, so both of you make some valid points as far as which interests are served, etc., regarding bail applications or bail. And it is about the balancing of interests. And one of the things is a bail, what purpose does bail serve? What purpose does bail serve? And the purpose of bail is a way to ensure that the accused does or will attend his trial when the trial date comes. And it's similar in the sense of, as we saw, that there were different ways in which we could secure the attendance of the accused in court. Could use summons, you could use indictments, you could use written warnings, you could also use an arrest procedure. And regarding the presumption of innocence, you must remember that until a verdict is given in court, an accused person is just that, an accused person. They've not been found guilty and pronounced guilty of anything. And so in that vein, or in that guise, to have someone incarcerated or imprisoned pending the outcome, because what is a grave violation of their rights to freedom and security of movement, etc. Because up until that point, this person has not been convicted of anything. And the only reason, in a sense, I will talk about the other reasons, would be to keep this person incarcerated if, and one of them being, he's a risk that he cannot be trusted to come to court on the date of his trial, or that he is such a grave danger to members of the public, or to himself, or to witnesses, etc. So I don't think it's absolutely fair to say that bail serves the interests only of the accused person. It also does, in fact, secure the interests of justice, as in justice as a whole, when we consider fairness and procedural fairness as well. And having gone through the slides in the audio, you'd have looked, and also at the Akerson case, you would have looked at what the considerations are for the granting of bail versus not granting of bail, okay? But we've seen, and like I said, we've seen on the news pretty much yesterday and today and the day before, regarding the Bushiri matter, where bail was granted with particular conditions, and now that bail has been violated and the Bushiris have absconded and left the country. And so again, not a guarantee, because the only guarantee that someone will stand trial would be to arrest him. So it's a fine balance between what is acceptable, what is not acceptable, what is fair, and how do you achieve that balance. And it comes down to what assets can be, what the conditions rather of those, what the bail conditions would be. So we'll run rather quickly through this, because I'd like us to get to the tutorial question where we can have a brief discussion. So yes, considering the time delays between arrest and the actual trial, forget the trial just starting, but the trial concluding, can be months, if not years. And there are things to consider, like whether the accused person in question has dependents, has a job, and what will happen to those dependents if this accused person is incarcerated pending the outcome of their trial. Right? But that's not the only consideration. There are very many considerations. The nature of the offense, of the suspected offense, the likelihood that the accused will stand or will evade his trial. And these are factual, practical matters that must be assessed on a case-by-case basis. All right. So constitutionality, then, the constitutionality is considered in section 35(1)(f) of the Constitution. And although the Constitution says everyone has the right to bail, it doesn't mean that everyone will be granted bail. Okay, the circumstances very much depend on that. And these are the two probably most frequently referred to cases in any bail application, Dlamini, Chitikat, and others, and Akerson. And if you'd watch the video that was uploaded regarding Ace Magashule's bail application, where you would have seen procedurally argument from the defense, argument from the state, right, regarding whether bail should be granted or not, whether he was a flight risk, and also, what he's willing to surrender, for example, passports, the bail amount, etc. You would have seen that these cases were referred to, and they are continuously referred to in pretty much all bail applications that I've been involved in. Yeah, so again, this is the question: do the interests of justice require that bail be granted? Okay, or bail not be granted? And the interests of justice means also looking at the interests of the accused person, not simply just whether or not from a one-sided perspective. So it's a holistic approach. What is, however, interesting to note regarding bail and bail applications is the process and the procedure, that it is not, and the burden of proof. Okay, it's not done on the criminal standard, it's done on the civil standard. Because the point is, when bail applications are not to determine guilty or not guilty. It's not the trial. It is to determine the likelihood that the accused person will come to court and will not interfere with other witnesses. Now, another aspect of for consideration, which you will find in your readings, is that sometimes bail is denied not because the accused will be a threat to members of society, but that members of society may be a threat to the life of the accused themselves. So that's also something to consider as well. Now, there's different fora under which bail can be considered and granted. Ideally, it should be done by a court, and that would be generally the magistrate's court. But there are such a thing, or such things as police bail and prosecutorial bail, and they do differ slightly, or in a sense, to what under what conditions and what types of offenses each can be considered in granted, and also how the bail amounts are paid. So you can have a look at that as far as the audio and the notes are concerned. For our purposes and what the tone of your tutorial question is we're going to be looking at court bail and procedurally what that means, the step-by-step aspect of that. And you can have a look at the notes for that. Now, as with anything, bail can be granted, bail can be denied. Both can be appealed, but who has locus standi, of course, to appeal that? Usually, if the state if bail has been granted and the state is unhappy, the state could certainly appeal against that. Alternatively, if bail is not granted, or if bail is granted but not in significantly strong amount, again, the state can can appeal that. And then if bail is not granted, the accused themselves can bring this matter on appeal, right? And what they can bring on appeal is the fact that bail wasn't granted at all. Secondly, any of the conditions regarding the amount of bail, or also conditions affixed to bail. And these conditions would be things like whether or not an accused person can travel outside of the province, outside of the state, areas or places that he or she may frequent, can travel to, things like handing over passports, reporting, etc. So if an accused person feels that those conditions are too strict or too stringent, they can take those on appeal. Yeah, and what's also different about a bail application compared to a trial properly is the role that the court plays. And here we would see that the court would then descend into the arena. So it takes a more proactive, more inquisitorial role, starting at the very beginning, particularly when it comes to undefended accused, where the court will say to an accused person, well, have you considered bail and would you like to apply for bail? Okay, so starting from that very point, the court takes a more of a proactive role and advises the accused in that respect. Okay. Beyond that, the court itself may say that, look, we need more information, go out and get this witness, go out, get that witness, get this information, get that information before we make a decision regarding bail. And usually in the trial, the court won't say that unless it's a matter for like a trial within a trial where something needs to be discussed or decided on that. The court will not descend into the arena in that fashion. We've discussed burden of proof. And procedure. Okay, so procedure is something also important. You can look at that when you look at your step-by-step, the step-by-step format that's required, and you can get a visual understanding of how that works by watching that video on the Ace Magashule bail application, right? But one of the points that's very important to raise in a bail application and has repercussions for the accused person if they are not raised is this whole thing about whether or not the accused has previous convictions, whether he is, number one. Number two, whether he is currently out on bail for another matter, because remember, bail conditions will read eventually that you must not be rearrested for a similar offense or another offense, because then your bail in that first matter could certainly be evoked. and what that revoked. And what that means for this matter is that because you have another bail, a bail, you're out on bail on another matter, that will certainly affect whether we release you on bail in this matter at all, or we just keep you incarcerated. Because the presumption is that the more matters you have pending against a person, the less likelihood it is that they would want to remain present for the trial and would probably abscond. But again, that's on a case-by-case basis, and there's no way of knowing for sure. Yeah. Now the bail amount, now this is an important question to raise, because you'll often find newspapers will report that, suspected rapist granted bail of 10,000 Rand or 1,000 Rand or 200 Rand. Now, how would that make you feel? What sort of emotions or response does that elicit from you or members of the public? What do you think that would elicit? What does the amount of bail have to do with anything?
Miss B, if you don't mind me.
Go ahead.
I think the amount of bail, it has to do with securing the reattendance of the accused or the proposed perpetrator to court proceedings in future, or to trial proceedings in future. But I think in terms of what feelings bail elicits, or the amount of bail, is that from a personal point of view, it's like you put in a price tag on my bodily integrity if I'm the person being violated, or you put in a price tag on maybe your life if you were killed in terms of murder. So I think it's like a strong feeling of dissatisfaction that you put in a price tag on something.
Yeah, that's an important perspective, because oftentimes members of the public do, and certainly not people who are not legally minded or legally trained, will take great offense, or take great unhappiness to hearing that a murder accused or a rape accused has been granted bail in an amount, with the amount being deemed in their perspective a low amount. In other words, they would say, but it's murder, it should be so much more, it should be 1,000,000 Rand, it should be 250,000 Rand. What is 1,000 Rand? What is 10,000 Rand? Those sorts of things. It's important to note that the bail amount is not meant to be punitive. It's not meant to be punishment. Okay? And the bail amount that is set is considers various aspects. It considers what can this accused person actually afford, right? Actually afford. And that means considering what the accused person's assets, finances, and means are. And it must be set then at an amount that they can afford, but certainly also at an amount that is sufficient enough to make them think twice about absconding. Because if one absconds, then the bail amount that has been paid becomes forfeited over to the state, and you lose that, and you will also then be arrested and have to stay in custody for the duration of the trial. So again, when we spoke about what sort of factors must be raised during the bail application, it would also be about finances, what assets the accused person has, what finances, what bank balances, what income, expenditures, etc. And so although one may feel that the amount is little compared to the nature of the offense, it doesn't very much have too much to do with that, as much as it's got to do with, well, what can the accused person properly afford to pay over? Think about it this way. If the bail amount is set so high that the accused can't possibly afford to actually pay it, it means that it might as well have been that no bail was granted, because you cannot leave, you cannot leave the jail system pending your trial up until and unless that amount is paid. So it mustn't be set at such an exorbitant amount the accused person can also not pay it. So again, it's a fine balance. Yeah. So what should be adduced? So when you're making a bail application, the accused, remember, is trying to prove to court that he's got ties with the republic, with the province, and that he has every intention and less, no likelihood, or less of a likelihood to abscond, right? To leave. So that he has a fixed residential address. What would the value of that be? Well, that he can be found, he goes to a home, he has a base. Fixed employment at the time period, again, that he has ties, that he has a place at work, that he will, be able to continue working in order to be able to pay legal fees, etc. And again, that he can be found and he has responsibilities. Now, the character also now, this is if it's in his favor, it also depends who's arguing what. So if the accused is saying, oh no, but I'm such a good guy, this is the first offense, etc., those are the sorts of things that you'd be raising. But remember, of course, that on the other side, that if character is raised, the state can certainly counter that. The nature of the offense, again, seriousness of the offense comes in, and also the seriousness of the type of sentence. And this is important because it does then raise into question, well, if the person is found guilty, what's the worst that could happen to them, and how does it color or affect whether or not they would actually want to stand trial to get that kind of verdict made against them. The probability and conviction, now this can come up on, depending of course on how far into the investigation matters are. Uh, yeah, ability to travel and settle in a foreign country, and this has to do with things like assets in another country, means, passports, like how much money, disposable income does the person have, can they just up and leave. Also, on the same vein, you'll be looking at like, well, does he or she have young children, school going age? It all goes on a case by case basis depending on what sort of arguments you wanted to make. Yeah. And considering Section 60 of the Criminal Procedure Act, which deals with what the considerations are, look at the Akerson decisions, which elaborates on that and says, well, what sort of things should we be looking at? How would we, as a court and as a prosecutor or a defense attorney, what are the pointers that I need to highlight? Just bring to your attention that health of the accused is one of the factors as well. Now, bail conditions has to do with, okay, fine, we're going to grant you bail and we're setting it at a particular amount. But while you are out on bail, these are the things that you are allowed to do, and these are the things that you are not allowed to do. And if you violate any of these conditions, you will be arrested and have to answer for that, or your bail will be revoked. Okay, and that's what the situation that we're seeing now with the Bushiri matter, where they're talking about extradition back from Malawi. Procedure after bail, this has to talk, because basically talks about where the money is paid off to, getting a receipt, handing over a copy of the receipt, retaining the receipt, and what does it mean for the matter and the trial once it is completed. Regardless of whether a person is found guilty or not guilty, once the matter is over, if they have been presenting themselves to court, even if they are found guilty, that bail amount will be repaid. Okay, it's not retained because it's not punishment. Okay, so the question I wanted us to consider is a set of facts provided on Moodle, make an argument in favor of bail and make an argument against bail. So I'm going to just put that question up in case if you haven't had an opportunity to look at that. Because it will help you consider just some practical aspects. Okay, any questions so far? Okay. So the facts are on the night. Okay, Tinashe, go ahead.
Sorry, Miss B, I just wanted to ask, especially in relation of what are the factors the court considers when granting bail. I think you would also even see it with the Bushiri case that I don't know if there was enough evidence or like uh, uh, enough inquiry into the case, because you would see that his children actually had gone also to Malawi even when they were arrested,
Yeah.
and even with the amount of the bill, I mean, it's someone who made over 100 million during the lockdown. So I don't know if like for 200,000 each was enough bill. So I don't know with the with what the court considers, to the even with the fact that they had just also saw that he didn't have he was illegally in South Africa actually. So I don't know, do what actually does the court considers in such
Yes,
cases?
exactly. So this Bushiri case does highlight a lot of questions as far as, well, how do courts exercise their discretion when it comes to bail application? And I think it will have to come back down to looking at the magistrate's reasons, because he would have had to give, or she would have had to give reasons as to why he is satisfied ultimately that this accused person is not a flight risk. And, you know, to an extent justify that the amount was not paltry and was certainly not. Now, obviously, hindsight is perfect sight, right? And no one could have possibly foreseen, I suppose, that this would definitely have had been the outcome, that they would have absconded. But yes, you do certainly raise a valid point that during that time, ties with South Africa were actively being severed, and the accused in that matter had uh, necessary means to, to just leave everything in South Africa, whatever was here, and move to back to Malawi. Um, so there's a number of major question marks. I think that this issue certainly is raising. I mean, you would think, and usually something like surrendering a passport is major enough for to ensure that the accused person will not uh, abscond, will not leave the country, will not travel. But you raise a valid point that were they here legally in the first place, and there's no way of knowing whether this person had multiple passports. Or forget multiple passports, but if they were able to come into the country in a particular fashion, surely that uh, the way to abscond or leave exists for them as well. Okay, so it's a difficult one. It's a difficult one to say, oh, the court should have and could have and ought to have, because it all depends on what types of arguments and what types of reasonings were given at that bail application. But certainly, unfortunately, there's no um, uh, tight answer. But I do think that the amount certainly was paltry. So let's contrast that then, right, because that was like a high profile matter. I think the nature of the offense was serious enough as well, and how would we deal with it? But here's something for us to consider. On the night of the 9th of August, Harry and his wife are disturbed by three intruders while at home on his small holding some 10 kilometers outside Pietermaritzburg. All the intruders are armed and proceed to tie up both Harry and his wife, but not before Harry sets off an emergency alarm linked to his neighbor. The intruders ransack the house and in the process take Harry's wallet, his wife's purse, and a TV set. Harry is then viciously assaulted and forced to open his safe, which contains two firearms and 15,000 Rand cash, being the monthly wages for his employees who work on the small holding. Thereafter, Harry is assaulted again, and so is his wife. All three of the intruders threaten to rape her and in the process of commencing this act, when they are disturbed by the neighbors responding to Harry's alarm, they flee into the darkness, but one of them is apprehended about 200 meters from the homestead. 10 days later, Sam is arrested in connection with the above attack. He is arrested at his home in Albert Falls, which is about 5 kilometers from Harry's small holding. His circumstances are as follows. He is 19 years old, is currently staying with his elderly maternal grandparents in Albert Falls. He's attending the local school and he's in grade 11. His form teacher has indicated that his academic progress is satisfactory, but that he is absent from school quite frequently. She is of the opinion that his grandparents are unable to exercise control over him, although they do provide him with his basic needs. Both his grandparents are pensioners struggling to survive economically. His grandmother is suffering from cancer and has been given 6 months to live by the doctors. His mother has remarried and is at present living in Durban. Occasionally, she sends support money to the grandparents, but Sam has not had much contact with her. His father has been deceased for more than 10 days. He participated in an identity parade where 2 accused were pointed out by Harry. Sam, however, was not identified. During a search and seizure operation at the time of his arrest, a shoebox containing 5,000 rand in cash was found under his bed. Sam alleges that this money was received by him for repairing radios. Sam has one previous conviction for theft of a bicycle, and this occurred in 2016. He was sentenced to 6 months imprisonment, suspended for 3 years. Okay, so how would you deal with this? What are the things that jump out for you? Let's just look at one thing. I just wanted us to consider right now flight risk. So there's a couple of things. If you were doing this as a full answer, I'm just going to stop the share here. If you were going to do this question as a full answer, you'd have to discuss a number of things, okay? Remember, of course, that the point of bail is whether or not the accused person is a flight risk. In other words, what is the likelihood that he or she will come to the trial? Other things is interference with witnesses. Another thing is amount of evidence currently against them. In other words, the likelihood of a guilty verdict. And that leads into also then what's the possible outcome as far as sentencing is concerned if found guilty. And the other factor in a bail application and argument would be the amount of bail that the accused can afford. Other factors, and sorry, I'm talking all over the show, is what sort of responsibilities or dependence does the accused have? In other words, in these and other cases, what will this mean for the rest of the family if the accused is held in custody pending his or her outcome, right? So let's deal with this first one, flight risk. Now, flight risk doesn't only mean will the accused leave the country. It comes down to, well, can we find this accused person? Will they leave the province? Will they leave their homestead? In other words, can they disappear? And it doesn't always have to come down to whether or not they are going to leave the state, the state as a whole, but it can also come down to whether or not they are simply just going to disappear, even within the borders of South Africa, right? From those facts, what do you think? What do you think we're looking at here? Okay, so how easy would it be for the accused in this matter just to leave? Okay, what sort of ties does he have here? Arguments certainly could be made to say that he is taking care, he's the caregiver for his grandparents, etc. But on the other side, well, he's got a mother in Durban. It's easy for him to disappear. But these can easily be remedied when we consider what if bail is granted. What sort of conditions? So, yeah, what sort of conditions? And that could be things like, well, he can go and stay with his mother, or he can remain with his grandparents, but he must report to a police station regularly, or he must go to school, start going to school regularly. Okay. Remember, and report to the teacher, and the teacher must give a report to the investigating officer that, look, he is in school every day. So again, those tie up with things like ties, financial, emotional, residential, and otherwise. Okay. So we're traversing various things, all coming down to flight risk. And the likelihood would be that this person should be granted bail. And then you'd also have to consider what amount that would be and conditions. So in an exam question, and how this question has appeared previously in exams, is it would be broken up into three parts. The first one is make arguments in favor of granting bail, or make arguments against the granting of bail. And the third part was, as the magistrate, make a decision. And that making a decision means also making a decision regarding the amount and conditions. But you can only do this if the financial and conditional aspects were also argued here by the defense and by the state as well. Okay, any questions on that? I know it might not be too clear to you now, but and also the audio only went up yesterday and the notes only went up yesterday. So have a look through this audio, the slides, and the tutorial, and give it a go. And we can discuss it at next week's Zoom session if you've got any questions around that. Any questions? Michael, go ahead.
Ms. B, I wanted to know what kind of structure you're looking for in terms of how we set out like the argument in favor, argument opposing, and also and then obviously us as a magistrate giving our presiding over it. It's basically in the structure of whichever one you support.
Okay.
So
yeah. Basically, how this will work is whether you're making arguments in favor or arguments against. Whichever one you start with, the other one will have to be counter arguments. And in either of the hats that you are wearing, or either of the arguments, and even the judgment you're going to be making, the considerations come under what those elements are in terms of Section 60 of the Criminal Procedure Act. And as you looked at Akerson, so you'd have to satisfy, if you're looking at what the likelihood is. Sorry, let me just open this up again. Let me share this. Right? So whether you're arguing for the state or you're arguing for the defense, and even as the judge making a decision, you have to consider this. So if you're arguing for the defense, you've got to deal with this question and say, look, I'm not going to abscond, I'm not going to forfeit. And then if you're arguing for the state, argue that no, the likelihood is that he will, okay? And same with the second factor and the third factor. All right, and as you can see from Akerson, it pinpoints to you what sort of personal factors or how you would consider what does that mean from a practical perspective. What does that mean from a practical perspective? Okay, so for whether you're arguing in favor or whether you're arguing against, you have to still deal with all of those sections. But obviously you're making arguments and counter arguments. So although the state says there's a likelihood that he's going to abscond, here's why he won't. All right. And even with the bail amount proposed by the state or proposed by the accused, as the state could oppose it. But to see how that functions, watch that the video that I uploaded of the application, bail application of Ace Magashula. So you could see how both parties argued these particular points. Is that making sense to you?
Yes, Ms. B. Thank you.
Okay. Any further questions? Okay, well, thanks everyone for joining the session, and I will see you all next week.